The Supreme Court chamber grew still as Jasmine Crockett stepped to the podium, her navy suit standing out against the dark mahogany walls. Cameras zoomed in on her confident smile, masking the tension that filled the room. Just moments earlier, Justice Stephen Breyer had interrupted opposing counsel with an unexpected remark. "I want to hear what Representative Crockett has to say." Her legal analysis in the brief was exceptional. Conservative justices shifted uneasily. Chief Justice Roberts raised an eyebrow, but what followed would send ripples through the legal community. As Crockett opened her case file, Breyer leaned forward and said words few expected from the 83-year-old justice. "Congresswoman, your constitutional interpretation challenges decades of precedent in a way I cannot dismiss. Please explain it to my colleagues." Whispers spread through the gallery as court officers called for order. Crockett remained calm, her gaze steady as she prepared to deliver an argument that would silence her critics and redefine how the court viewed this skilled Congresswoman from Texas. Before we explore this remarkable moment, remember to like and subscribe to stay updated with our latest political and Supreme Court coverage. Representative Jasmine Crockett was no stranger to high-stakes legal battles. Before Congress, she had built a reputation as a formidable civil rights attorney in Texas, taking on cases most considered unwinnable. Her rapid rise, from state legislator to member of Congress, was driven by viral clips of her sharp questioning and her gift for translating complex legal issues into plain language for the public. But today's hearing was different. The case centered on voting restrictions that disproportionately affected minority communities, a fight that had defined her career. For weeks, conservative media dismissed her as inexperienced and overmatched. "She's a freshman congresswoman pretending to be a lawyer at the Supreme Court," one Fox News commentator scoffed. "Breyer will eat her alive." Justice Stephen Breyer, nearing retirement, was known as a pragmatic liberal, focused on how laws functioned in the real world. His philosophical questioning style and meticulous legal writing had influenced American jurisprudence for decades. But that morning, seasoned court observers noticed something unusual in his demeanor. As Crockett's case was called, he seemed fully absorbed, almost studying her. You could tell he'd read her brief multiple times, noted court reporter Nina Totenberg later. It was covered in highlights and notes. Knew that Crockett had spent months developing a new legal argument, one that challenged recent voting rights decisions without directly confronting the conservative justices who wrote them. Her approach drew on neglected historical records and Reconstruction-era legal principles, reframing the debate without overtly partisan language. The stakes could not have been higher. The ruling would determine voting access for millions, especially in communities of color. If she failed, restrictive laws would stand, shaping elections for years to come. Conservative think tanks called her theory dangerous and a radical reinterpretation of settled law. As Crockett arranged her papers, Justice Samuel Alito leaned toward Justice Thomas, both exchanging quiet, dismissive smiles. Justice Barrett tapped her pen, impatient, yet Breyer's attention remained fixed on Crockett, as if recognizing something his peers had overlooked. "Congresswoman Crockett," Chief Justice Roberts began, "you have 30 minutes to present your argument. I remind you, this court has addressed these issues recently, and precedent is clear." Crockett nodded politely. "Thank you, Mr. Chief Justice. Yes, I'm fully aware of the court's precedents. That's precisely why I'm here." The stage was set. Crockett began calmly, her measured tone a sharp contrast to her fiery congressional persona. "Justices," she said, "I direct your attention to Section 2 of the Voting Rights Act, which this court has interpreted as requiring proof of discriminatory intent rather than discriminatory impact." Justice Alito cut in. "Congresswoman, that was settled 2 terms ago. Are you asking us to overturn our own precedent?" His tone carried a trace of condescension. Crockett didn't waver. "No, Justice Alito, I'm asking you to apply it correctly." She lifted a document rarely discussed in her briefs. This statistical analysis wasn't available during that case. "It shows that under your test, the pattern still reveals discriminatory intent that cannot be explained by any factor other than race." The room stiffened. Directly challenging a conservative justice was bold. Observers exchanged quick glances. Was this politics or genuine legal argument? Then, unexpectedly, Justice Thomas spoke. "Congresswoman, These statistics could be read in several ways. What makes your interpretation the right one? Before she could answer, Breyer interjected, "If I may, Justice Thomas, the methodology aligns with what we accepted in Johnson v. Alabama, 1987. It's quite sound." Turning to Crockett, he added, "Please continue, Representative." The exchange was unprecedented, a liberal justice actively reinforcing a congresswoman's argument against conservative questioning. Reporters scribbled furiously. Something unusual was unfolding. Crockett pressed on, layer by layer. She cited rarely discussed precedents that forced the justices to consult their binders. When Justice Barrett questioned her reading of a 1980s case, Crockett replied by quoting Barrett's own 2006 Law Review article, which supported her view. "Justice Barrett," Crockett said respectfully, "in your article, you noted that statistical patterns of this scale create a presumption that shifts the burden to the state to prove non-discriminatory intent. I'm simply applying that logic here." Barrett appeared taken aback. Clearly not. Expecting her scholarly words to be used this way, the tension rose as Crockett continued dismantling each conservative point with calm precision. She avoided theatrics, relying instead on the strength of her reasoning. Justice Kavanaugh tried another line. "Congresswoman, even if we accept your analysis, doesn't the state have a compelling interest in preventing voter fraud? These measures seem narrowly tailored for that." It was a classic trap, meant to make her appear dismissive of election security. The audience held its breath. Crockett smiled slightly. "I appreciate that question, Justice Kavanaugh." She reached for another document. "We reviewed every voter fraud prosecution in this state over the past 20 years. There were 13 cases, none of which would have been prevented by these measures." She paused. The courtroom fell silent once again. However, these measures would also block an estimated 740,000 legitimate voters from casting their ballots. "If we're discussing narrow tailoring," Crockett continued, "I'd suggest this is the exact opposite." Justice Breyer gave a subtle nod. The conservative justices exchanged quick glances. As Crockett's time drew to a close, Chief Justice Roberts, who had been notably quiet, finally spoke. "Congresswoman Crockett, your statistical analysis is compelling," he said. "However, this court has been reluctant to intervene in state election processes unless a clear constitutional violation is shown." It was the opening Crockett had been waiting for. "Chief Justice," she replied calmly, "I understand the court's caution. That's why I've saved my most significant argument for last." She reached into her briefcase and produced a bound document none of the justices had seen before. "This," she said, "is a recently uncovered congressional record from the debates surrounding the 15th Amendment. It includes statements from the amendment's authors directly addressing the kind of state actions at issue today." The justices looked surprised. Authentic new historical materials from that period were extremely rare, and any that shed light on original intent were treated with great seriousness. "I had this authenticated by historians from 3 universities," Crockett continued. "It shows that the framers of the 15th Amendment explicitly intended to prevent states from creating procedural barriers that would disproportionately affect newly freed slaves' ability to vote, even if those barriers did not mention race." Justice Breyer leaned forward. "May I see that document, Congresswoman?" As Crockett handed it to the clerk to deliver to him, the tension in the chamber rose. She had saved a major revelation for the final minutes, an approach that could either reinforce her argument brilliantly or be dismissed as a last-minute tactic. Breyer examined the pages closely, his expression becoming more animated as he read. The other justices looked on, clearly unsettled by both the unexpected evidence and Breyer's reaction. "Justices," Crockett concluded as her time expired, "these records, I believe, provide the precise constitutional grounding the Chief Justice requested. The framers of the 15th Amendment anticipated this exact scenario and sought to prevent it." The red light signaled the end of her allotted time. Normally, that would mark the close of her argument. But before Roberts could move on, Breyer spoke. "Mr. Chief Justice," he said, "I believe the court would benefit from allowing the Congresswoman a few additional minutes to elaborate on this historical evidence. It's quite remarkable." The room fell silent. Extra time was rarely granted, especially at a justice's request. All eyes turned to Roberts. After a pause, he nodded. 5 additional minutes, Congresswoman, he said. Please focus on the relevance of this document to our current jurisprudence. As Crockett began her extended remarks, the legal reporters present realized they were witnessing something extraordinary. The atmosphere in the chamber had shifted. The Congresswoman, once dismissed as inexperienced, now held the full attention of the nation's highest court, with one of its most respected justices openly supporting her line of reasoning. No one could have predicted what would happen next. Crockett stood poised at the podium, the extra 5 minutes unfolding like an unexpected gift. The document she'd introduced had clearly impressed Justice Breyer, though the others remained cautious, some curious, others skeptical. Justices, she began, her voice clear and measured, please turn to page 37 of the congressional record. She paused, then continued. Here, Senator Charles Sumner, one of the 15th Amendment's architects, states, the amendment must not merely prohibit explicit racial barriers to voting, but must empower Congress to address procedural mechanisms that accomplish indirectly what states are forbidden to do directly. Turning the page, she went on. And here, Representative Thaddeus Stevens adds, a state may claim a neutral purpose, such as preventing fraud, yet design requirements that impose heavier burdens on freedmen. The amendment must reach such subterfuge. Justice Thomas leaned forward. Congresswoman, while historically interesting, how do these remarks alter our analysis, given that this court has consistently held that disparate impact alone cannot invalidate election regulations? It was the opening she had anticipated. Justice Thomas, Crockett replied. That's exactly why these records are so crucial. The framers of the 15th Amendment didn't only forbid explicit racial discrimination in voting. They specifically addressed facially neutral procedures that impose unequal burdens. She paused briefly, meeting the eyes of each justice. But I'm not asking the court to rely solely on disparate impact. What these records reveal is that the original understanding of the 15th Amendment included what we'd now recognize as a burden-shifting framework triggered when certain statistical thresholds are met. Breyer's eyes widened slightly. He flipped through the document to a page he had already marked. Congresswoman, are you referring to Senator Howard's comments on page 42? Crockett smiled. He had found it himself. Exactly, Justice Breyer. Senator Howard proposed that when a voting procedure reduces participation among black voters by more than 1/3 compared to white voters, the state must demonstrate a compelling and necessary justification. That's remarkably similar to the standard this court applies in other constitutional contexts, Justice Barrett interjected. But Congresswoman, even if we accept that this reflects the original understanding, the court's jurisprudence has evolved over 150 years. Are you suggesting we abandon decades of precedent? Not at all, Justice Barrett, Crockett answered smoothly. I'm suggesting that this historical evidence shows how the court's current approach has drifted from the 15th Amendment's original intent. Returning to that foundation would actually bring greater consistency to the court's voting rights doctrine. She then produced a chart from her brief. This analysis demonstrates that applying the original understanding would affect only a small number of voting restrictions, specifically those with the most severe disparate impacts. Most election administration laws would remain untouched. Justice Kavanaugh, now visibly uneasy, tried a different line of questioning. Congresswoman, even if we find your historical analysis persuasive, what's the limiting principle? Justice Kavanaugh leaned forward. Would this approach invalidate all voter ID laws? Not at all, Crockett replied confidently. Only those that meet the statistical threshold and where the state cannot demonstrate a necessary and compelling justification. Many voter ID requirements would remain valid if states provide free IDs and ensure fair access. She anticipated their concerns, addressing each point before it could become an obstacle. Observers in the gallery watched as Crockett systematically countered every objection with calm precision. Chief Justice Roberts, known for preferring limited rulings over sweeping changes, posed a question. Couldn't we resolve this case on narrower grounds without re-examining our entire voting rights framework? Crockett recognized the opening. Yes, Mr. Chief Justice, you could, she said. The statistical evidence alone, under existing precedent, would justify a ruling in our favor. However, the historical record offers this court an opportunity to bring much-needed consistency to an area of law that has become fragmented and difficult for lower courts to apply. Then the courtroom fell completely silent. Justice Breyer, who had been studying the historical record throughout Crockett's extended time, closed the binder and looked directly at his colleagues. I've spent nearly 3 decades on this court seeking to understand the original meaning of our Constitution's voting protections, he began, his voice measured and clear. And I must say, in all my years, I have never encountered historical evidence this persuasive on this precise issue. His statement lingered in the air. Known for his pragmatic rather than originalist approach, Breyer's endorsement of Crockett's argument, grounded in original intent, spoke directly to the conservative justices on their own interpretive terms. Congresswoman Crockett has uncovered a historical record previously unknown to this court, Breyer continued, and demonstrated how it fits within our current framework without creating the jurisprudential disruption some may fear. Justice Alito, visibly uneasy with Breyer's remarks, interjected. Justice Breyer, are you suggesting we overturn a decision from just 2 terms ago based on a document not included in the original briefing? Before Breyer could answer, Crockett responded, Justice Alito, I'm not asking the court to overturn its prior decision. That case required proof of discriminatory intent, and I accept that holding. What I'm showing today is that the statistical evidence in this case meets that intent requirement when examined properly. The historical record simply clarifies why this framework aligns with the Constitution's intent. Her reasoning reframed the issue effectively, respecting precedent while giving the court a logical path to rule in her favor, without overturning its own recent decision. Justice Breyer nodded. Exactly, Justice Alito. We wouldn't be overturning precedent, only applying it with a fuller understanding of the constitutional context. By this point, the atmosphere in the courtroom had shifted entirely. What had begun as a routine presentation by a relatively new Congresswoman had evolved into a compelling demonstration of constitutional interpretation, with one of the court's most respected justices openly supporting her view. As Crockett's extended time ended, Chief Justice Roberts addressed her with an evident change in tone. The court appreciates your detailed presentation, Congresswoman. Crockett collected her documents, exchanged a brief nod with Justice Breyer, and returned to her seat. The opposing counsel approached the podium, visibly unsettled. The state's attorney had prepared for traditional voting rights arguments, not a historically grounded originalist position supported by Justice Breyer. In the press section, reporters hurried to send updates to their editors. A rare event had just unfolded, and headlines were already taking shape. Justice Breyer endorses Crockett's constitutional argument, unexpected alliance on voting rights. What followed in the justices' private conference would prove even more consequential. 3 days later, the Supreme Court's press office issued a rare and unexpected announcement, one that hinted at something truly historic. Sarah, the Supreme Court had requested supplemental briefs on the historical evidence presented by Congresswoman Crockett. Constitutional scholars across the political spectrum recognize this as an exceptional development. The court seldom sought additional materials after oral arguments ended, and when it did, it often indicated a major reconsideration of the justices' approach to the case. Inside the marble chambers of the Supreme Court, the impact of Crockett's presentation was still being felt. Sources speaking on condition of anonymity described the post-argument conference as unusually tense. One insider revealed that Justice Breyer had been more assertive than usual, telling his colleagues that ignoring Crockett's historical evidence would amount to intellectual dishonesty of the highest order. It was a rare display of firmness from a justice known for his collegial tone. Meanwhile, back on Capitol Hill, Congresswoman Crockett returned to find her office overwhelmed with media inquiries and constant phone calls. Major outlets, including CNN, MSNBC, and even Fox News, were competing for interviews. Her social media presence had surged overnight, with the hashtag #Crockett Constitution trending nationwide. "I just presented the facts and the law," Crockett told reporters gathered outside her office. "The Constitution doesn't belong to one political party or ideology. It belongs to every American, and its protections must apply equally to all voters, regardless of race or location." Conservative media initially downplayed her performance. "Political theater from a freshman congresswoman," one Fox News host remarked. But legal experts across ideological lines offered a different view. Harvard law professor Alan Dershowitz, known for his independence, told CNN, "What Congresswoman Crockett presented was a remarkable combination of historical research and constitutional reasoning. The court would find it difficult to ignore evidence this strong, regardless of ideology." Similarly, prominent conservative originalist scholar Randy Barnett tweeted, "As someone committed to original public meaning, I find the newly uncovered 15th Amendment debates both fascinating and potentially important for our understanding of voting rights jurisprudence." Inside the court, opinions remained divided. According to insiders, Justice Thomas, initially dismissive, had instructed his clerks to verify the authenticity of the historical records and review their context. Justice Barrett, whose own academic writings Crockett had cited, was reportedly reassessing the statistical findings through this historical perspective. 2 weeks after the oral arguments, Justice Breyer made an unexpected appearance at a judicial conference at Yale Law School. Although Supreme Court justices rarely discuss active cases, Breyer spoke in general terms about constitutional interpretation. "Sometimes," he told the audience, "we face moments in our jurisprudence when new evidence or analysis challenges our established views. In such moments, intellectual honesty demands we ask whether our precedents have drifted from the Constitution's true intent. This is not about politics or ideology, it's about commitment to the law." Everyone in attendance understood the implication. Without mentioning Crockett or the case directly, Breyer was signaling that her arguments merited genuine consideration. Outside the court, the political effects were growing rapidly. Voting rights groups rallied behind Crockett, with one launching a national campaign titled "Stand with Jasmine" to emphasize the case's importance. Civil rights leaders held prayer gatherings outside the courthouse. Even former President Barack Obama weighed in, tweeting praise for Crockett's brilliant and principled advocacy, a message that quickly went viral across social media platforms. Representative Jim Jordan appeared on Fox News to criticize Congresswoman Crockett, calling her efforts another attempt by the radical left to federalize elections. But when the host asked him about the specific historical evidence Crockett had presented, Jordan hesitated. "I haven't personally reviewed those documents," he admitted. 3 weeks after the oral arguments, the story took another major turn. The Washington Post published a detailed investigation confirming the authenticity of Crockett's historical materials. The documents had been found in a previously uncatalogued collection belonging to Frederick Douglass, who had attended many of the congressional debates surrounding the 15th Amendment. The Post's headline read, "Crockett's bombshell evidence confirmed authentic by historians." That same day, in a rare public comment, Justice Clarence Thomas spoke at a Federalist Society event. While not directly mentioning the case, he emphasized the importance of original intent in constitutional interpretation. When clear historical evidence reveals the original public meaning of a constitutional provision, Thomas said, judges have a duty to align their rulings with that understanding, even if it requires reevaluating precedent. Legal analysts were stunned. Was the court's most conservative justice signaling openness to Crockett's argument? Speculation grew rapidly. 45 days after oral arguments, the Supreme Court announced it would release its decision the following Monday. The long delay suggested complex opinions were being written and that some votes may have shifted. The night before the ruling, Crockett appeared on 60 Minutes. "Whatever the court decides tomorrow," she said calmly, "I believe we've already changed the national conversation about voting rights. These aren't abstract legal theories. They determine whether millions of Americans can exercise their most fundamental right in a democracy." Monday morning, Crowds gathered outside the Supreme Court hours before the decision's release. News networks went live, and court blogs crashed under heavy traffic. At 10:00 a.m. sharp, Chief Justice Roberts began reading the opinion. In a 6-3 decision, the court rules in favor of the petitioners, he announced, sending shockwaves through the courtroom. Crockett had won, and at least one conservative justice had joined the majority. Roberts continued, "While this court has previously held that proof of discriminatory intent is required to invalidate voting procedures under the 15th Amendment, the historical evidence presented in this case provides essential context for understanding how such intent can be established." He went on to explain that the court was adopting a modified framework. When statistical evidence shows a severe disparate impact on minority voters, the burden shifts to the state to prove that its procedures serve a necessary and compelling interest. This approach, Roberts concluded, aligns with both our recent precedents and the original understanding of the 15th Amendment, as revealed in the congressional debates surrounding its adoption. Justice Breyer delivered a concurring opinion from the bench, an honor reserved for decisions of great importance. Today, the court demonstrates that faithful constitutional interpretation belongs to no single judicial philosophy, Breyer stated. Representative Crockett's exceptional historical research and legal reasoning remind us that the Constitution's protections for voting rights are substantive and enduring. In a separate concurrence, Justice Barrett, joined by Justice Kavanaugh, wrote, "The statistical framework developed by the petitioners, viewed alongside the historical evidence of the 15th Amendment's original public meaning, provides a balanced approach that protects both state sovereignty in election administration and the individual's fundamental right to vote free from discriminatory barriers." Justice Alito, joined by Justices Thomas and Gorsuch, dissented. Today's decision marks an unwarranted departure from recent precedent, relying on historical evidence that, while interesting, should not override established jurisprudence in this area. As news of the ruling spread, Crockett's phone buzzed nonstop. President Biden called to congratulate her on the historic win. Civil rights leaders hailed the decision as the most significant voting rights ruling in decades. Law schools immediately added the case to their constitutional law syllabi. When Crockett stepped out of the courthouse, hundreds of supporters cheered. Reporters shouted questions, but she raised her hand for silence. Today, the Supreme Court reaffirmed what should never have been in doubt. "The Constitution protects every American's right to vote," she said. "It prohibits states from creating systems that deny that right under the guise of neutrality. This victory isn't mine. It belongs to every citizen whose vote was at risk, the senior who can't access an ID office, the parent who can't wait in line for 8 hours, the student whose campus polling place was closed." That evening, returning to her office, Crockett found a handwritten note waiting for her. She immediately recognized Justice Breyer's handwriting. "Representative Crockett," it read. "In nearly 3 decades on the court, I have rarely seen advocacy that so perfectly combined historical insight, constitutional clarity, and practical wisdom. You have not only shaped this case, you may have reshaped the course of voting rights jurisprudence for generations. The Constitution and the country are better for your efforts. With admiration and respect, Stephen Breyer." Crockett carefully folded the note and placed it in her desk drawer. Turning to her staff, she said, "We've won a battle, but the fight for voting rights continues. Let's get back to work." In the months that followed, the ruling's impact spread across the legal and political landscape. States with restrictive voting laws rushed to revise their systems. Law reviews published special editions analyzing the court's new framework. Constitutional scholars developed case studies based on Crockett's advocacy. Crockett herself became a national figure, mentioned as a potential future Supreme Court nominee and sought after for her constitutional expertise. The freshman Congresswoman, once dismissed as inexperienced, was now leading masterclasses on constitutional advocacy at top universities. A year later, Justice Breyer announced his retirement. At his farewell ceremony, he reflected on the case. "Even after decades on the bench, we judges can still learn." Representative Crockett reminded us that true constitutional interpretation requires humility and moral courage. Her advocacy in that case remains a highlight of my judicial career. When reporters later asked Crockett about his comments, She smiled. Justice Breyer taught us that the Constitution isn't frozen in time, but its core protections endure. When brilliant legal minds approach it with honesty and integrity, as he always did, justice prevails. I'm just grateful I had the chance to argue a case worthy of his intellect and values. The story of Jasmine Crockett and Justice Stephen Breyer would be studied for generations, a reminder that in America's system, one determined advocate with the right argument at the right time can alter the course of constitutional history. Thanks for watching this incredible story of how Jasmine Crockett's sharp legal mind earned Justice Breyer's respect and reshaped voting rights forever. Don't forget to like, subscribe, and turn on the notification bell for more powerful stories about justice and the people shaping America's legal future.